topic is on base erosion and profit shifting, which we commonly call as BEPS. So we are going to just see an overview today, and you will be seeing it in detail in the upcoming classes, upcoming sessions. So can anyone say what is base erosion and profit shifting?
BEPS was basically introduced to reduce the tax evasion. Some countries were shifting their profit towards another country where there is no tax or the tax rate is less.
Yes.
So BEPS was introduced to avoid that.
Exactly. So it was going on an international level. There was a growing perception that MNEs were escaping tax and they were engaging in aggressive tax planning. And it wasn't illegal what they were doing, because they were avoiding tax by engaging in tax planning, and they were not involved in tax evasion. Can anyone say what is the difference between tax evasion and tax avoidance? So tax evasion is when the tax is due and we are not paying the taxes. So that results in tax evasion and it is prohibited by law. It is illegal. But tax avoidance means we are avoiding the taxes by engaging in tax planning schemes. So like for example, if we take it in a smaller scale, a salaried individual, he invests in various funds and gets ATC deduction, ATD deduction. So that is tax avoidance, tax planning. And MNEs, they were on an international scale engaging that. So it was becoming a global issue that made the necessity to bring out BEPS action plan. OECD introduced BEPS action plan, 15 action plans they have introduced. So, and this issue, no single country can unilaterally solve this issue because it was going on a multinational level. Say there is a company in India, they were eroding the taxes by shifting their profits or showing large interest, royalty and other expenses to some foreign country. And on the whole, they were only be in the group companies. So internally they were having group profits, but their base erosion. They were not paying enough adequate taxes for the Indian government or any other government. So base erosion and profit shifting, if we go by the literal meaning, it has two words in it, base erosion and profit shifting. So what is base erosion? Base erosion means reducing the tax base by claiming deductions and expenses like interest, royalty, or any such of expenses they will claim and reduce the tax base. Profit shifting means they are shifting the profit. So while reducing the taxes, they are paying huge amount of interest to some foreign country. And in that foreign country, that will be taxed as their income. But maybe the foreign country interest is taxed in some other way. So there won't be any corporate tax on it. Or it is in a low tax area or nil tax. So key causes of BEPS. So as I said, there wasn't causes of BEPS. So as I said, there wasn't any single cause for BEPS. The main cause was tax evasion. And the gaps and inadequacies between the domestic laws and the tax treaties. So these MNEs were taking the benefits of tax treaties and engaging in treaty shopping. And engaging in incidents where they were paying nil tax or low tax. So, and there are very complex transactions. These group entities always engage in very complex transactions, and so many countries will be involved. Ultimately, their goal will be to avoid taxes. So, there are many causes for BEPS. This OECD action plan, it was focused on main three pillars. So the three pillars were coherence, substance, and transparency. Coherence means integration of domestic law with the international level. So domestic law and international treaties, there are many loopholes. So we wanted to eliminate the loopholes and bring a integration among them. Next was taxation and substance. So they wanted to focus on the substance. On what is the substance or what is the purpose for the companies to shift their profits or to do this transaction. So they wanted to see the basic substance between each transaction. And transparency. So with OECD 15 action points, there have been engaged a lot of transparency between countries, and exchange of information is happening on a global level. So basically, the action points were divided as these. There are 4 objectives: transparency, restoring effects, establishing coherence, and turning tax policies into tax rules. And basically, the action plans were divided on this. I think this is self-explanatory. So relevant dates and events. Which date is more important is the October 2015, because the BEPS action package was published and endorsed in this date. And after it, MLI opened for signature. And for India, October 2019, the MLI came into force. So the BEPS drafting started in Feb 2013, and it took 2 years for them to draft the BEPS report. That is BEPS action plan. So you will just see an overview of all the 15 action plans. So the first one is the addressing the needs of tax challenges of the digital economy. So when the domestic laws and all were when domestic laws and all came into force, it was years before. Like it was around in the 19th century. And that time no one would have guessed that technology would come so far. In that time, there was a perception if an MNE wants to earn profit, they need to have a physical place in India or physical place in any other country. So this gave the way to many digital economy challenges. So the issue was the MNEs were earning profits through digital presence. They did not need a fixed place to run their business. So they were engaging in profits and they were not paying taxes also because they didn't have a fixed place or paying. So these were the issues: significant digital presence and application of source rule. So this action plan is still work in progress. Yeah. It hasn't. There have been original proposals, but it hasn't come into force into full effect. Still, Pillar 1 and Pillar 2 is in work in progress, and there have been discussions going on. So most probably next year they will introduce the Pillar 1 and Pillar 2. And in every action plan, we can see whether it is not a minimum standard or a minimum standard. Can anyone say why this is written? So not a minimum standard means there wasn't any compulsion for the countries to adopt these standards. So out of the 15 action plans, only 4 action plans were compulsory in nature, which needs to be adopted by all the countries. And remaining action plans were not a minimum because it is like an ideal thing to do, but it wasn't compulsory. And there wasn't any compulsion to adopt this action plan also. So as I said, the OECD inclusive framework still it's working on Pillar 1 and Pillar 2 to address the challenges of the digital economy. So before this work in progress itself, India has taken steps and it was the pioneer in introducing equalization levy. As we also saw equalization levy in our earlier sessions, can anyone say equalization levy?
To tax the digital transaction,
Online
advertisement and e-commerce
operators. Equalization levy was levied at 6% on online advertisements and 2% on e-commerce operator. They even amended the section 9(1) to include if there is a significant economic presence, then it would also constitute a business connection and it would be deemed to be income, accrue or arise in India. So India was the pioneer in taking those steps. But till now, these rules and all are not relevant with the Pillar 1 and 2. Because that is still in work in progress. So when Pillar 1 and 2 will come into effect, we can see a different set of rules and provisions coming into India. And maybe there are talks that equalization levy would be abolished. And some other concepts will be coming in, which will be in the line with the Pillar 1 and Pillar 2.
They also talk about significant economic presence only, right?
Yes.
So it is kind of in line with BEPS MLI.
No, that pillar 1 and pillar 2 is still work in progress. They will decide only in the next.
So you have
Next
mentioned
year.
significant economic presence in the first slide.
That was just the proposals.
Proposal.
The final report consisted of proposals, but the recommendations, detailed recommendations, it was still, the OECD is still working on it. So maybe we can see new rules and provisions coming next year. So action plan 2 is neutralizing the effect of hybrid mismatch arrangements. See, example of hybrid mismatch is there will be some instruments or entities which have hybrid nature. Hybrid, can anyone say the meaning of the term hybrid?
Compound.
It's a mixture of both.
Mixture of both. So two or more characteristics. So if it is a convertible debenture, CCDs, we can take that example. It has the characteristics of both debt and equity. So it is a hybrid instrument, and one country would be treating that differently, another country would be treating it differently. And the MNCs would take this advantage of these loopholes and escape tax and engage in tax planning. And an example of hybrid entity is partnership firm or trust. So partnership firm in India, we can see the share of profit of the partnership of in hands of the partners, it's not taxable. So we consider partnership firm to be liable and as a separate legal entity. But in some countries, partnership firm, it's not taxable. Partnership firm is not taxable in some countries. In some countries, those profits. In some countries, the profits will be taxed in the hands of partnership firm, and in some countries, it will be taxed in the hands of partners. So there is a gap here. There is a mismatch between the arrangements between one country and another country. So this would lead to a condition where they will be obtaining an exemption in one country without a corresponding base of taxation in some other country. So it will lead to double non-taxation. And as we can see, it is not a minimum standard, so it is upon the countries to adopt or not. And the main reason is because of lack of coordination between tax legislations, this is happening. So they have recommended some hybrid mismatch rules. The OECD recommendations, they have recommended some set of rules, linking rules and all, which would be seen in the detail in the upcoming sessions or upcoming slides. So when the question raised that what are the issues in India, as I said, because of preference shares, partnerships, convertible debentures. But when the question raises that as it is seen as raising BEPS issue in India, the question to this was probably according to experts in India, it was no. Like India had few cases and few judicial precedents, but it wasn't a situation of concern, raise of concern in India. And accordingly, no changes have been made in the domestic tax law. I think it's clear. Next, we will go to Action Plan 3, designing effective controlled foreign company rules. So, can you even say what is controlled foreign company? Or any idea about what this could be? So, what is a CFA is? See, there is a company, holding company in India, and it is having a subsidiary in Mauritius or any other company where the tax is low or nil. So the Indian holding company will transfer its profits to the subsidiary company. And the subsidiary company, they won't be engaged in any active business or such thing. They would be designed only for the purposes of tax evasion. So, and then that entity would be a CFA. It is a controlled foreign company of India.
Like controlled international transactions.
So they have established some rules. We have to see there are three approaches in this. First approach is jurisdictional approach. Jurisdictional approach, there are three approaches. So first approach was based on whether India or any other country, the holding company has 50% control over the subsidiary company. Then only it will be called as controlled foreign company. And the next approach is whether they have passive income. If they have active income, doesn't comes into count because active income means they are doing sales or engaging in any activities and earning profits out of that. So we can't take that profits into controlled foreign company. If they are having passive income in sense interest, royalty, on any such expenses which are transferred from the holding company to the subsidiary company. And the third approach was combination of both. So it was lot of subjective in nature because you have to check each and every transaction. And the rule recommended that then those profits would be taxed in the hands of the holding company. It would be taxed in the hands of the resident shareholders. If they are earning, if the foreign subsidiary company is having passive income and 50% or more control is in the hands of the holding company, that is the Indian company or any other company in this case, then it would be taxed in the hands of the resident shareholders. And OECD also action plan sets of 6 building blocks for this, where they have given in detail the rules how to compute income, how to prevent and how to eliminate double taxation, the threshold limits, exemptions, and it was not a minimum standard. So India basically didn't thought that controlled foreign company rules were necessary to be adopted in India, but they didn't introduce CFC in India. But they tried to establish somewhere near to something called CFC, which is POEM. You all know what is POEM, place of effective management. So they amended the section 6(3), which defines a company which is a resident of India. They included the word place of effective management. So make the definition broader and wider and to include more companies. So what was this effect was more companies came into a definition of PE, definition of Indian company, and they were liable to tax in India. So they didn't adopt CFC in this same case, but they have made some measures. They have taken some measures. Next is Action Plan 4, which is limiting base erosion involving interest reductions and other financial payments. So what OECD and BEPS considered is they are claiming a lot of the companies, MNEs are involving in a lot of interest expenses, and they are claiming a lot of deduction in the amount of interest expenses. And India has also taken a measure towards this interest deductions. 94B. So the OECD recommended a fixed ratio rule to EBITDA, that is earnings before interest, tax and depreciation and amortization, or EBIT. So they kept the range to cover 10% or to 30%. So our interest expenses should be that much only. And it covers all interest expenses, even the domestic interest expenses, related parties, third party cross border. So all the interest expenses together, it should be below 30% of the EBIT as per Indian law. And OECD recommended that it should be between 10 or 30%, also monetary threshold. And this term interest was also wide, it include interest of all forms of debt.
What was the group ratio? Maybe based on the debt among the parties, group, they might have.
So fixer was based on EBIT and group was based on some other measures. So when the question raised that is interest deductions perceived as raising BEPS concern in India, it was actually no according to the experts. But the Indian government, however, introduced a section 94B, and we have also subsequent clause in tax audit which disallows the expenses under this section if it exceeds 30%. So next is Action Plan 5. Action Plan 5 talks about two parts. First one is countering harmful tax practices, and the second one is making information taking out into transparency and substance. So it involves exchange of information between the countries. So while all these action plans were against talking about the MNEs, this action plan took into account the countries. was saying that many countries are giving into benefits of many preferential tax regimes and many countries were giving preferential tax regimes to many to encourage foreign investors, which was actually competing with other countries, and it was termed as harmful tax practices. And the second point, as I said, it was lack of transparency as regards regarding certain tax rules. So suppose there is a tax ruling between two countries, if any person is involved in international transaction, it would be a resident of some country and it would be a case in some other country. Like we saw in Mr. Fowler's case, it was between UK and South Africa. The person was resident in South Africa and he earned some income in UK, and the issue was whether it is taxable or not. Then it was in the court of UK. So the UK government has a liability to produce this information, to convey that information to South Africa, to where that person was resident. So it will ensure tax transparency of information and exchange of information. And the information needs to be transferred to the immediate parent entity, resident of the immediate parent entity. If it is a group of companies, then the parent entity, where the parent entity is resident, there that information needs to be transferred. And they brought out this nexus approach for IP registries. Intellectual properties, we shouldn't see where the legal ownership is. It should be determined based on some factors and where the research and development activities are considered. So intellectual property companies were engaging in such practices. They were registering the legal ownership of IP in one country, which is very low tax rate or nil tax rate, like we saw in the case of Starbucks. As Latte Ganesh was explaining, Starbucks case. So to limit this approach, nexus approach was taught, which said that where the research and development activities, where the IP rights are protected, where the activities regarding the development management of IP is conducted, there it should be taxed, and accordingly between the ratio it should be split and taxed appropriately. So these were the measures to reduce the harmful tax practices followed by both the countries, and the BEPS was to evaluate the tax regimes, preferential tax regimes followed by different countries.
It's a minimum standard.
Yes, it is a minimum standard. And there was even a peer review. Peer review means the preferential tax regimes given by one country will be reviewed by other countries. So if they find it to be harmful, then they will be informed to the OECD and accordingly action will be taken. So India generally is not seen in indulging in harmful tax practices.
115 DA, BPA and all.
That is not harmful
It's not
because it
harmful,
is
it's
having
only
a set
beneficial.
of stringent conditions involved with it. Any tax benefit like we have, we always have a stringent conditions along with it. We don't just give simply tax benefits to anyone. So it is not called harmful tax practices. So next one was preventing the granting of treaty benefits in inappropriate circumstances. So in this case, this was a minimum standard. This is a minimum standard. So, and options were given by the OECD for the countries. There were three options. First one was limitation of benefits clause. So, limitation of benefits clause was to be introduced in each treaty, which limits the benefits given in the treaties. And the principal purpose test. Principal purpose test means what was the principal purpose of this activity? Was it to avoid tax? Then tax benefit won't be given. Like if we take an example of 115 BAB, if a company is purposefully incorporated to avail this benefit, then that benefit cannot be claimed. So in each of the activity, we need to see the principal purpose test. And the third option was a combination of both, LOB and principal purpose test. So if the principal purpose of the arrangement is to obtain treaty benefits, then that benefits won't be given. And it was all a lot of subjective in nature because it will vary with countries to countries. And the next was common intentions to eliminate double taxation. So nowadays in all the treaties we see in the preamble, we have a line that it is to provide treaty benefits as well as to eliminate double taxation without creating opportunities for treaty shopping. So this statement was expressly introduced in all the treaties, and India has adopted this. So this is the BPT clause, principal purpose. When one of the principal purposes resulted directly or indirectly in that benefit, then that granting would be allowed. These were some other issues in that action plans. So what were the issues in India? We can see many countries were engaged in treaty shopping. Like in the Mauritius case also, many companies were just forming a company in Mauritius and investing to Mauritius in India because it had low tax or nil tax. At that time, it was a tax haven. So in that case, we also saw the Vodafone case, looking at and looking through. Azadi Bajao, that day I was discussing about that case. And the government has taken various measures like guard provisions also to avoid this treaty shopping. Next is preventing the artificial avoidance of PE status. As we all know, only the business profits are taxable only when there is a PE in that corresponding state. So many MNBs were avoiding this PE status and were not getting liable to tax rates. So even there was a commissioner arrangement where there was a dependent agent and the agent was carrying out all the works. He was only getting the customers and getting the contracts executed, but it was in the name of the enterprise. It was in the name of the principal. So that wasn't considered as PE earlier, but nowadays it has come into the definition of PE. And it was in the Article 5.5. So they have proposed the article changes that dependent agent should also come into the definition of PE. So in India, the implication became the definition of PE was amended and it became more stringent. And it was implemented to multilateral agreements. MLI, you will see in Action Plan 15. And certain business models were to be treated reconsidered. Action Plan 8 to 10 was with aligned transfer pricing outcomes. It was mainly regarding the transfer pricing arrangements, and it was that if a entity is bearing certain risk, it should also get the corresponding returns to it. And as I said in the IP approach, the development management of IP rights need to be considered. And if we are doing something, it should be a corresponding value creation with it. So next is Action Plan 11, measuring and monitoring BEPS. So when the BEPS took out 15 action plans to avoid tax erosion or tax avoidance, they also took out the action point to measure and monitor the BEPS. And this is more of a administrative in nature and does not lead to charging any changing of provisions or any charging provision or any change in provision. Because before BEPS, the MNEs were engaging in tax planning and avoiding taxes, which was estimated between 4 to 10% of global CIT revenues. So to counter this, BEPS have been taken out, and one of the action plan 11 was to monitor. Their OECD had recommended some tools to monitor the effectiveness of the BEPS in the country. Action Plan 12 was the mandatory disclosure rules. And this is not a minimum standard. This rules tell that when a MNE is engaging in some aggressive tax planning or doing some tax planning, it will upfront by itself disclose this to the government. And the disclosure was mandatory. Then the government would evaluate whether it is tax planning or tax avoidance, and it would suggest some measures. The taxpayer can report. Can give the disclosure, or the promoters of the company can also give a disclosure. This was mainly introduced to identify such schemes. And BEPS implementation in India, it is not been adopted, it is not mandatory as it was not a minimum standard. India didn't adopt this standard. And no changes are made in the domestic tax law. Action Plan 13, we are all aware of, it is TP documentation, India has adopted it. And we also have the master file and country by country reporting. So OECD recommended three-tiered approach. One is the country by country report, then the master file and the local file. So India has adopted this approach and we have country by country reporting mandatory for MNEs, large MNEs who have transaction who have the group turnover exceeding 6,500 crores. And the master file part A and part B is there, which is applicable. Part A is applicable for every entity, and part B is applicable when the international group turnover exceeds 500 crores and the international transaction exceeds 50 crores or the intangibles exceed 10 crores. And a local file, we all know we have to maintain a TP documentation. So they inserted a new section called section 286, which talks about the master file and country by country reporting. Action Plan 14 was making dispute resolution mechanism more effective. So this is a minimum standard. As you all know, before BEPS, now BEPS have been introduced. So there are 15 action points. Any new thing has been introduced and it would lead to lot of disputes between two countries or between the persons or between the MNEs. To resolve this dispute, there should be a minimum mutual agreement procedure and a dispute should be resolved. Dispute should be resolved through this manner. And all the OECD and G20 countries have agreed on this minimum standard regarding mutual agreement procedure. And there was even an arbitration process, but India has not adopted this arbitration process. Only 20 countries have adopted this arbitration. That is, which cases are not being solved by mutual agreement procedure, then we go to the arbitration court. Action Plan 15 is for developing a multilateral instrument to modify bilateral tax treaties. So, can anyone say what is MLI?
It's a treaty. It's a type of treaty signed between both the countries.
It is an instrument that modifies the existing bilateral treaties. See, all this Action Plan 14, we saw it needed to implement this BEPS package. It required amendment of domestic laws. So domestic laws is not a problem. Whichever country wants to amend the domestic law, they will amend it accordingly. And it also required the amendment of OECD Model Convention, based on which the bilateral treaties are signed. So that Model Convention was also amended accordingly. OECD commentary gives the instructions for the OECD Model Convention, and that was also amended. But the point or the issue was, how would a country amend the tax treaties? DTAAs. DTAAs, it's based upon negotiations between two countries, and that takes, even basically speaking, one treaty to negotiate, it takes at least a year, minimum a year. So there are more than 3,000 treaties. If each treaty needs to be modified, it would take more than a decade. So practically that wasn't possible. So they introduced as Action Plan 15 MLI. MLI was an instrument to amend all the treaties at one go. Basic motto between us was one negotiation, one signature, one ratification. And the countries need not individually modify one treaties or amend one treaties. They can then sign one treaty called MLI. So the action plans to be implemented through treaties. Through that MLI, 4 action plans are to be implemented. These action plans we already seen before. These need to be implemented through the multilateral instrument. This is the basic structure of the MLI. And these are the articles of MLI. So MLI modifies the operation of the existing tax treaties. Say, if example, if a domestic law is amended, we can see the amendment in the section itself. if explanation 3A and 2A was amended, in that section sir, we can come to know it is amended. But MLI doesn't amend the treaties, it just modifies the treaty. So an MLI and a tax treaty needs to be read together to understand the benefit for us, to understand the interpretation of law. And each party to the MLI, that is, each country will specify which treaties need to be modified, which treaties apply to that treaty is called as covered tax agreements. And the countries had the flexibility to implement BEPS tax treaties. If there was a minimum standard, there are 4 minimum standards. That minimum standards, there was a choice how can be satisfied. And more than a minimum standard, they had the option to opt out, that they won't agree on this standards. They can make the reservations to opt out of the provisions or part of provisions that are not minimum standards. Either with respect to all the covered tax treaties or a subset of covered tax agreements. So reading an MLI and a tax treaty together and interpreting the situation was difficult, practically not easy. So what India introduced was a synthesized text, where the effect of MLI is already there. So if whenever we go to a double tax agreement, avoidance agreement, we have 2 agreements, comprehensive agreements and the synthesized text. So synthesized text, the effect of MLI is in there. So these are the various action plans and corresponding articles which were amended. So we will see into these articles detailed in our upcoming sessions. Thank you.